Hi, I'm David Sobel, and I'm a Michigan and Ohio real estate attorney. And every week I sort through emails and letters with questions from clients and friends that relate to real estate contracts or financial disputes. So today's question comes from Margarita L., who bought a home in Trenton, Michigan. And in her email to me, she says that before she closed on her home, she was already aware that the basement had a leak. So she says that the seller actually disclosed the leak on the seller's disclosure statement, and which is good. And then the seller actually showed her where the leak was in the basement, where they thought the leak was coming from. So they call it the source of the leak. So Margarita wants to know if the seller is liable to her now if it turns out that the cause of the leak is not coming from the same source that the seller had once thought or had disclosed. In fact, according to Margarita, what's going on now is she has to actually expend a lot more money because she has a much bigger and more expensive foundation issue than she anticipated. So she now wants to know her rights against the seller. It's a great question. It occurs quite a bit. We handle in my office quite a few home seller disclosure issues. And first of all, Margarita, there's really nothing wrong with purchasing a home that has a leaky basement because basements do leak. However, if a seller sells their home and fails to disclose to the buyer that they knew about having past water problems in their basement, well, that becomes a problem. It poses a legal issue of liability for the seller. But whether Margarita's seller is liable for the leaky basement after they disclosed in good faith what they had thought was the source of the water leak, now that's going to be a completely different and difficult determination. So before we get into specifics about Margarita's situation, let me just tell you generally that in every residential home sale in Michigan and Ohio, a seller has to complete a home seller's disclosure statement. And the seller's disclosure notice or statement is a legal document that gives the buyer the details of the condition of the property to be sold. And this form should not be taken lightly as it is a legally binding document, and home buyers can rely on the representations that are contained in the home seller's disclosure. So according to real estate law, a seller needs to actually provide a good faith disclosure for any known material defects affecting the home. And here's, there's quite a few on the seller disclosure list, but here's a few. We want to know when the property was last occupied by the seller. What was the roof's condition like? What about the heating and air conditioning or the plumbing system? How about the electrical system? Any structural problems with the home? Also, what about any additions that were made to the property, or when you're remodeling the home, or any structural changes to the property? The Disclosure Act will also want to know about water and sewage or water service areas. So if a seller doesn't know about a home's material defect, they're not going to be able to, and they can't disclose something that they don't know about. For instance, if there is a problem with the home's heating system that is later discovered by the buyer 3 months later after closing on the home, the seller is really actually protected because if in good faith they disclosed it, they're not going to be liable. But if the seller knew that they had a problem with the furnace and then they failed to notify the buyer, they would be actually violating the law and expose themselves to quite a bit of legal liability. Additionally, the real estate seller disclosure law does not require the seller to undertake any specific investigation into any defects or inquire into items on the list when they complete the disclosure statement. So what that means is that the seller is really not going to be required to go out and uncover items they're really not knowledgeable about, and they're not really required to have any knowledge of a licensed home builder or contractor either. Okay? So the seller disclosure should not be considered a warranty against defects. It only relates to the material defects that are known to the seller when the disclosure statement is completed. That's it. That's all that's required. So Margarita, as well as any other buyers that are watching this, you should not substitute the seller disclosure statement for a home inspection by a licensed home inspector. And you should always have a home inspection. So instead, the buyer should actually use that disclosure statement in conjunction with a home inspection report. And you should use that to uncover any defects with the home that the buyer and seller are not aware of. Okay, and this is especially true in your case, Margarita. In light of this very brief overview of the seller disclosure law, I think it's going to be very difficult for you to press a case against the seller, okay? Because This is especially true when you already were disclosed, the seller already disclosed where they thought the water leak was, okay? And the problem here is, the argument is that once you knew that the basement had a leak, you were actually put on notice that the water was coming into the basement, and you could have gone out and had your home inspector delve further into where the leak was possibly coming from, or you could have even had a foundation expert or foundation company come out before you continued with the transaction, just to ensure that the leak was not more serious than what your seller had believed it to be. You were put on notice that the basement leaks. Okay? So if the seller made a good faith disclosure as to where they thought it was coming from or the source of the water was originating from, that's all they needed to do. Now, if they hid the source of the water, such as putting boxes up against, let's say, a cracked wall at the time of the disclosure, then that's going to be a different case and one that you would probably want to pursue. But you'd actually have to prove that they intentionally concealed or hid that water leak issue. Okay? So from your facts, Marguerite, I would not waste your money on hiring an attorney. Instead, I would put that money to good use and towards the repair work with a reputable foundation company. I know it's not what you really want to hear, but I believe in telling you actually what others won't. Okay, I hope you found my information helpful today. And for those of you who are still watching, if you like what you heard and you learn from the video, please take time and care to share it with your friends and your family. You can also leave a review on what you liked about the video, and you can also input in the comment section anything else that you might, any other topics, legal topics that you would like for us to discuss. If you wish to submit your question or your concern to us, you're also, just like Margarita, then what you can do is you can email us at team@provenresource.com. Finally, I also want to let you know that I just released a new book about a month ago. It's called Shady, and it's titled Shady, How to Protect Yourself When Doing Business with Friends or Relatives. You can download that book for free by going to our website, which is www.provenresource.com. Hopefully you'll enjoy it. I think it's very helpful, very easy to read. It's very intuitive. And finally, I never assume that you never really need anything from me, but if you have any questions related to real estate law, contract law, or financial disputes, please feel free to give me a call at 888-789-1715. And I just, again, want to thank you for watching. We hit a milestone recently with over 100,000 videos watched just in Metro Detroit alone. So thank you again for watching, and have a great day.